So we're to now for the Senzo Meyiwa murder case to discuss. We're joined by legal analyst Mpumelelo Zikalala. Mr. Zikalala, thank you for being with us, as always. The former Brigadier Ndlovu has been called a key state witness. How important do you think his testimony would have been?
It would have been very important. Let's remember, it would have been one of the very first people to be at the scene. So it's very important when it comes to the collection of the evidence that is there. Whether the forensic evidence which was analyzed and linked to all the accused that are in court is indeed the accurate one, is it the evidence or the information that ought to have been used in collecting those particular 5 accused. Linked to that, it's the stage of maybe the other people that were in the house. What were the utterances? Are there any statements that were obtained? Any eyewitnesses that would have given out statements earlier, so that at the end of the day, it is easy to collate that particular evidence. Let's remember, the state has a very important job to do here, because it has to prove beyond reasonable doubt that indeed the 5 accused, which are in the dock, are indeed the 5 individuals that should be held accountable for the murder of Mr. Senzo Meyiwa. So the death of someone who's not going to be able to come to court and say, this is what I saw, this is what I've done, the ability or the lack or the inability of cross-examination of the particular evidence makes it very difficult for that evidence to be used unless it is accepted by both parties or it is not disputed, of which in this case I do not see the defense simply accepting the evidence, the written submissions or affidavits which should have been received by the deceased.
Apparently, he also had some information relating to the suspected shooter. Somebody had approached him who gave him that information about what happened on the day that Senzo Meyiwa was killed. Now, could that still be revealed if he wrote an affidavit or if other officers are aware of what he was told? Can that evidence still come to light?
It can be revealed, even though the weight which would be attached by the court to the particular evidence won't be as much as it would have been had it been that person would have been the person to give that evidence. Just remember, you can submit whatever evidence that you need within the particular court, but the most important question is the admissibility of that particular evidence. Linked to that is how probable is that particular evidence is, and it is able to solve a certain mystery, in this particular case, the motive that would have been there. So during the cross-examination, during the examination in chief and re-examination, the motive of what was the killing all about would have been revealed. Those particular individuals that would have came to him would have been able to come in, and he would have been able to testify as to what exactly did they say to him. Can he pinpoint them? Are they part of the witness list? What is it that they saw? And the manner in which this particular process was investigated. Let's remember that when police men go to in the dock in any criminal cases, they want to prove that everything was followed to the T in terms of the procedure. Everything was done according to the Criminal Procedure Act. There's nothing wrong in which they did, and indeed, the evidence that they've used is the one in which they would have held the 5 accused which are in the dock as individuals that must be held accountable. So if we don't have that individual there who took and collected the evidence, we don't have the individual who was being given by informants, for example, certain information, or certain people would have whispered to him and said, please look in this particular direction. If we don't have him to be able to be cross-examined, and if there is no consensus between the parties, in this case the defense and the state, to say let's simply accept this particular evidence, it's certainly going to be a very hard hill to climb, especially for the state. Which is why we always say it is crucial for the quality and the quantity of the evidence to be dealt with as soon as possible. And this talks directly to why matters have to be started and ended within the shortest amount of time. These delays lead to these particular consequences in which key witnesses are going to be either be forgetful or would actually die, as in this case. Now, leaving the family behind is the real sufferers or the real people who are going to feel the pain, because they are the ones who are not going to know what is the truth pertaining to the death of their loved ones. Yeah. What was the real motive of the killing of Mr. Senzo Meyiwa?
And the context here is that the defense has asked for an earlier resumption of the trial, saying that witnesses are in danger. There's a lot of conspiracy claims around this case. Will the death of this key witness, even though he was retired and elderly, fuel those theories?
It definitely it will. But the most important one is that let's remember that we are trying to protect the rights which are in the Constitution. The rights of the accused, which it's a given as per Section 35 that the trial must start and end within the shortest amount of time to prevent these sort of things from happening. And it's also the right of the victims in this case. Because at the end of the day, the Meyiwa family deserves to know the truth as to what actually happened. Now, if you are going to find people who are going to die, we don't know the circumstances regarding his death. However, it poses a risk to the completion of this particular trial. It poses a risk to the integrity of this particular trial, which is why it's even more important that the judge ought to listen to those submissions which are going to be made by the defense in this case. If they have allegations of any tampering of witnesses, any evidence which may be lost, any witnesses' lives which are at stake, it ought to put that on record so that there are precautionary measures that can be taken to prevent those particular things from happening in the near future. All that is required and what the court would look for is the truth. And the only individuals that can be able to deliver the truth is the witnesses, so their protection is of utmost importance.
Yeah. Surely the state provides those services. There are protection services for witnesses potentially in danger.
Mm-hmm. Yes, it does, maybe when it comes to ones who are at the danger of assassination. But there's something in which the state cannot do. The state cannot stop a person from being forgetful due to the lapse of time. Now, let us look at when this matter started. It started 8 years ago. Then the question is, can a person who was investigating this particular matter be able to remember accurately what happened 8 years ago, and so that they can be able to give evidence that is crisp, that is probable, and probably which will not be, when tested, will be able to test whatever test the court will put it through. And linked to that is the process of saying, can you be able to get all of them into one room or into one session so that at the end of the day, you are able to bring this matter to finality? With all the resources which are available to the state, it can't stop the person from being forgetful, and most importantly, it can't stop the person from or keep them alive. So they are going to find instances where witnesses are going to die, and unfortunately they die with valuable information which has been able to ease and sort of provide the comfort in which the victims need in this case, which is the truth.
Yeah, what a pity for everybody who just wants to find out finally what actually went on here. All right, we'll continue to follow the trial. Thank you as always for your analysis, Mpumelelo Zikalala.